Good afternoon. Today is Monday, December 22nd. So we're really getting close to the Christmas day. Is everybody excited? I'm getting there as much as I can. But I like the season. I like looking at all the lights and looking at all the presents under the tree, and so, yeah, but it's also the season for people to get sick. And right now I'm dealing with my husband isn't feeling very well. And, it's always funny how when husbands don't feel well, they insist on coming out to the living room area. And am I frozen? Or am I freezing? Okay. And laying on the couch in the middle of everybody, in it where you feel uncomfortable doing anything around the house because you don't want to disturb them. Women, when we're sick, we want to be alone. So we stay in bed. We'll turn the TV on in there if we feel the need, but we stay in bed for the most part. Stay out of people's way, but man, they got to make sure that everybody knows they don't feel good. And the only way they can do that is to be out in the middle of everybody, and then you say, have you eaten anything? Oh, I don't know. Do you think I should? Yeah, you should. So you feel obligated to fix them something. It's crazy. Have you taken anything? Yeah, but I could probably use some more. It's just insane. You'd think I'd be used to it by now, but I'm not. So I don't know. So that's why I didn't go on earlier today, because he finally felt good enough to get up and go out to the shop and do some work, I guess. Because I told him I wanted to go live, so I think he kind of felt bad, oddly enough. But do any of you have that problem? Because it just kills me how they say they're so strong and tough, but they catch cold and it's over. That's how strong and tough they are. Women spit babies out of their vaginas, okay? I'd like to see a man try to do that. They have zero pain tolerance. That was kind of crude, and I'm sorry. But anyway, I was originally going to finish the summary or the motion for summary of I can't think of the name of it, with the Mickey Stein's case, civil case. I was going to finish that today, but we've had some developments in Kelsey Fitzsimmons' case, not just her criminal case, but also her family court case. Justin responded, put in his response to Kelsey Fitzsimmons' parents motioning for the grandparents' motion, for visitation of the baby and whatnot. So we're going to go over that. And then the SJC handed down their ruling for Kelsey Fitzsimmons to be released. And I'm sad to say that it's not in our favor, and it breaks my heart. What the actual fuck is going on in Massachusetts? They have their shit so jacked up. It's like it's a never-ending shit show there. I mean, they are the laughing stock of all justice systems, I believe. You have Karen Reed, and this is nothing bad about Karen, but this is just a comparison. You have Karen Reed, who was going on trial for murder, vehicular manslaughter and murder, for drunk, and it was basically the basis of her charges were drunk driving. She was released on what I believe it was a $100,000 bail originally, and then they had it reduced to $80,000 bail with no restrictions other than she couldn't get another driver's license. Her driver's license was suspended or revoked or whatever. But she didn't have a GP, she wasn't on house arrest. She didn't have a GPS bracelet. She didn't have to be monitored for alcohol. She didn't have to report to a probation officer. And she was on trial for murder. Okay? And she definitely had the resources to leave the area. And she didn't have, her parents and her brother are here and her sister. But other than that, she had nothing to tie her here. She didn't have kids of her own, so there was nothing binding her here to guarantee that she was going to make it back to court. But nonetheless, she was out on bail, okay, with no restrictions. Then you have Kelsey Fitzsimmons, who is an Andover police officer. No criminal history. Of course, Karen Reed didn't have any criminal history either. But she's an Andover police officer. She's not being charged with murder. She's being charged with assault with a... None of her charges have anything to do with alcohol. Well, that's the only charge she has. But it doesn't have anything to do with alcohol. And she has a baby here, tying her here. So she's not going anywhere without that baby, okay? And she was, they finally got her released on bail, but she had all these restrictions. She was on house arrest. She had a GPS monitoring bracelet, and she had to do this scram testing for alcohol, okay? What in God's name, how can the two cases differ so much in the release of the accused in the same state? Can somebody tell me that? I don't get it. I do not get it. I don't know how two cases can be so handled so differently. It just blows my mind. Karen Reed never had a problem with dangerousness. She didn't have to have a dangerousness hearing to see if she was a danger to the community before they let her out. But Kelsey Fitzsimmons does? Are you freaking kidding me? Get your shit together, Massachusetts. This is embarrassing. There's no rhyme or reason to the way they handle court cases. None. And I'm not saying that every judge needs to fall in line with the other judges, but for Christ's sake, have some kind of, continuity. So that people can kind of see what goes on here. There's no telling what's going on. If somebody walked up to me from Massachusetts and said they were being charged with this and what can they expect or whatever, not that I would know. I'm not a lawyer. But I would say, you know what? It's a coin toss. Depends on who you get, where you go, and what mood they're in. It's a freaking coin toss in Massachusetts. And it's so freaking infuriating to watch. Two innocent women both being railroaded by the Commonwealth. Do they have something against women there? I'm starting to think they're very misogynistic, obviously. So anyway, we're going to cover those two papers instead of continuing on with Mickey Stein's civil suit for now. Tomorrow we will possibly finish Mickey Stein's I still can't remember. I swear I'm having a stroke. Is it summary judgment? I don't know. I have no idea. I'm so freaking irritated that I forget shit like that so easily. So, let me get going on this. It just breaks my heart. So she definitely needs our help now as far as funds go and whatnot, because they're going to try and keep her in there the duration. By the time she goes to trial, even if she's found guilty, she will have served her time at the rate they're going. So here we go. Notice, all slip opinions and orders are subject to formal revision and are superseded by the advance sheets and bound volumes of the official reports. If you find a typographical error or other formal error, please notify the reporter of decisions, Supreme Judicial Court. Basically, this is an unpublished hard copy of the decision. So there might be errors is basically what they're saying. This is the non-published version. Kelsey Fitzsimmons v. Commonwealth, December 22nd, 2025. Pretrial detention. Assault by means of a dangerous weapon. Supreme Judicial Court. Superintendents of Inferior Courts. The petitioner, Kelsey Fitzsimmons, appeals from the judgment of a single justice of this court denying her petition for extraordinary relief pursuant to general law. Gives the case. We affirm general law C-211. We affirm. Well, that's not sounding good. Background. Fitzsimmons stands indicted in the Superior Court in Essex County on one count of assault by means of a dangerous weapon. Not murder, mind you. A dangerous assault by means of a dangerous weapon. Crap. Oh well. I don't know why it's in a box now, but that's okay. In violation of General Law C-265. In connection with an incident in which the Commonwealth alleges that on June 30th, 2025, Fitzsimmons, who is a North Andover police officer, was served by police with an abuse prevention order, and after deceiving officers about the location of her firearms in her home, she drew a firearm, pointed it at one of the officers, and pulled the trigger. Okay, now for those of you that don't know the background to this story, Kelsey Fitzsimmons is an Andover police officer. She and her fiance, Justin, who is a firefighter paramedic, had a baby, a little baby boy. Okay, and Kelsey came down with postpartum depression / psychosis. Very bad case of it. Very bad. Well, they were supposed to get married this October, just like a couple months ago. So for his and her bachelorette party, they decided to take some friends away for the weekend and, celebrate. I believe they went to the Cape, but I'm not positive. So they're away for the weekend, June 30th, I believe, the weekend before July 4th. And they had their bachelor/bachelorette party. Apparently, according to Justin, Kelsey got pretty drunk, which is no surprise to me. It's a bachelorette party. What are you supposed to do? Everybody knows that's what happens. I don't know why everybody's acting like that's such a surprise or a shock. Oh my God, she got drunk. Anyway, she's apparently hit him or slapped him. They got in an argument. She hit or slapped him. She came home. He didn't come back to the house. They lived together in Kelsey's house. She owns the home. And she went about her life, she figured he was coming home when he cooled down or whatever. He didn't. So it's pretty clear that he's chilling things down a bit with her and doesn't really feel like going through with their plans, apparently. So Anyway, somewhere during that week, I don't know where he stays or whatever, but the day of this event, the day this happened, he called Kelsey and asked her to bring the baby and meet him at a park. Okay. So she's, of course, excited. So she goes to meet him and she stays there for like 3 hours waiting for him. And little does she know, he's got a friend watching her, keeping Justin apprised of what she's doing because Justin is at the courthouse trying to get a stay away order on Kelsey. Okay? And the whole bit about him calling her to meet him at the park with the baby was a ruse so that he could have his friend watch her and know what she's doing and report back to Justin so that, he could do this without any kind of rebuttal from her. Okay? So for 3+ hours, she waits at the park for him. He doesn't show up like a piece of shit that he is. And she goes home. So she's breastfeeding the baby on the couch, and all of a sudden there's a knock at the door, and it's her ex-partner, Officer Noonan, and some other police officers that she works with, okay? And she, mind you, this day, very same day, she got reinstated as a police officer. She got clearance to go back to work. She was supposed to start work on the 4th of July. Back and everything else, okay? She's been cleared to go. So she's an officer at this point. Well, she always was, but she was on leave. So they tell her, we have a restraining order for you. Okay? So she says, okay. And they said, and by the way, you're no longer a police officer, and we have to take the baby from you. Okay? So this is a lady that just got off of a leave of absence for postpartum psychosis. And they show up to her house to take her job away, her baby away, and to give her a restraining order for Justin. Okay? They don't bring any kind of social worker with them. They don't bring any kind of a negotiator, nothing. They just the police officers whom she works with, okay? What kind of shit is that? I mean, you just basically took all of her wind out of her sails. You might as well just punched her in the hole in the chest, I'm sure she couldn't breathe. I'm sure her head was spinning. She didn't know what was going on. And this piece of shit played her like, like a trumpet or whatever. And to have her coworkers serve her with these papers and to tell her that she's no longer got a position as a police officer is bullshit. I don't think that should have been put on them, and I think that they should have had an outside department serve her. And I think they should have made sure that there was a social worker there available to her in case she, lost it. Because you're basically taking everything she has to live for away from her in one fell swoop. So anyway, she says, okay, let me pack a bag for the baby. The officers go in the house with her. They ask her where her guns are. She says they're all in the basement in the vault. She has to go upstairs to get some more clothes for the baby. She's in the room. And according to Officer Noonan, her ex-partner, she lunged. Now, it doesn't make sense because he says she was kneeling or sitting on the ground or on the floor, and she lunged behind a door and grabbed her gun. Well, first of all, how can you lunge if you're sitting? Okay. Second of all, her house has no doors on any of the rooms. There's a Zillow listing of her house, and if you look at it and take the virtual tour, there are no doors on any of her rooms in that house. So what door did she lunge behind? Okay. So anyway, he says that she lunged, grabbed the gun, pointed it at him, and pulled the trigger, and Kelsey Fitzsimmons says that she pointed the gun at her own head, pulled the trigger, and it didn't go off, so she tried to rack up around, okay? So Officer Noonan proceeds to shoot Kelsey at close range in the chest. It says he fired 2 shots. She was hit once. They don't say where the other bullet went. I don't know why they don't care, but to me it's pretty important where it went. But anyway, so they had to life flight her out. She spent 55 days in the hospital. She had 7 or 8 major surgeries. The bullet broke some ribs. She had a hemothorax. It nicked her liver and her kidneys. She still has bullet fragments in her back, so she's in pretty bad shape. And they indict her in the hospital and handcuff her to her bed for the remainder of her stay in the hospital. She had her first hearing via Zoom from her hospital bed. Okay, so that's the background of this case, and they finally got the judge to agree to release her with restrictions. And like I said, it was GPS bracelet or monitoring, house arrest with her mom and her stepdad, and she had to do random alcohol testing through a scram device, and she had to blow really hard, really long, 4 times a day. And they didn't know at the time that was ordered that it was going to be so painful, and she was having really hard time with it. She was doing it, but she was in a lot of pain. So they went to the court, requested that they change the mode of testing, and basically the judge threw her back in jail. She was a rude bitch. I mean, if you hear the audio of the hearing, it's unbelievable how she sounded. She was just a cunt. There's no other word for it. And so she threw her back in jail. She said, if you're not willing to do this, then you're going back to... And it's like, okay, well, they should never have... They called it a bail revocation, which it wasn't. It was just the judge refused to offer another mode of testing. So anyway, they took it to the SJC to appeal it, and this is the SJC's decision that we're going to go over. So here we go. We're going to finish. That's the background of the story. When the firearm did not discharge, Fitzsimmons allegedly attempted to, quote-unquote, rack a round of ammunition, during which time the officer twice yelled, quote-unquote, Kelsey, don't do it, or other words effectively instructing Fitzsimmons to drop the firearm. And that's another thing, is he said, Kelsey, don't do it, don't do it. He never said drop it. And most officers, if a gun is being pointed at them, they say drop it. But if the assailant or the suspect is pointing the gun at themselves, what do they say? They say don't do it. So I think that right there is pretty solid proof that she was pointing the gun at herself. And there are witnesses that say, other officers that say he never said drop it. The officer then shot Fitzsimmons in the chest. Fitzsimmons was originally charged in the district court with 1 count of armed assault with intent to murder in violation of general law, and then it gives the number, and 2 counts of assault by means of a dangerous weapon in violation of general law 265. Upon a motion of the Commonwealth, she was held on dangerousness grounds pursuant to, and then it gives you the law. On a petition for review, a Superior Court judge likewise found Fitzsimmons dangerous and ordered her detained. And this girl is like 5 foot nothing, maybe 120 pounds at the most. She's a tiny girl. On August 25th, 2025, Fitzsimmons was indicted in the Superior Court. The grand jury declined to indict her on a charge of armed assault with intent to murder. That's huge, because they always say that you can get the grand jury to indict a ham sandwich. Well, they didn't agree that she was intending to murder anybody. And instead, Fitzsimmons was indicted on a single charge of assault by means of a dangerous weapon. A conviction of that charge carries a state prison sentence of not more than 5 years. And since she has no criminal background, she probably would have been let go on probation. At the rate it's going to take that long to try the case. As it had in the district court, the Commonwealth moved for detention on the basis of dangerousness pursuant to General Law 276. In support of its request, the Commonwealth submitted a number of documents, including a police report detailing the June 30 shooting incident, as described supra, as well as an affidavit and witness statements concerning the incident and the alleged events leading up to it. In one such statement, Fitzsimmons' former fiancé alleged that at a party on June 28th, Fitzsimmons became intoxicated and violent, striking him multiple times and making suicidal statements and threatening statements concerning the couple's young child. I don't remember that. I remember him saying he was in fear for her and possibly his child, but not by her. He didn't say that she threatened to hurt the child. All of which prompted the former fiancé to seek an abuse prevention order. He also allegedly warned police that when they served the abuse prevention order on Fitzsimmons, she quote-unquote would attempt to kill the baby, any officers involved, and then herself. What a piece of shit to say that. Another witness statement indicated that Fitzsimmons had, quote, struggled with mental health issues, aggression, and alcohol abuse, end quote. I've never seen anything about her struggling with alcohol abuse. I don't know why that alcohol is playing such a big part in this case, but they act like she's a junkie. She wasn't drunk. She wasn't drinking when this incident happened. She was drunk the weekend before at her bachelorette party. Who doesn't get fucking drunk at their bachelorette party, I ask you? The Commonwealth also submitted the affidavit of Fitzsimmons' former fiancé in support of the abuse prevention order, which echoed the above-described representations and further represented that Fitzsimmons had been, quote-unquote, sectioned in the recent past, and she was also cleared in the recent past. Actually, that day, she was cleared to go back to work. They would not clear her to go back to work if she was still having psych problems, you know? It doesn't sit well with me. Finally, the Commonwealth submitted an out-of-state criminal history record indicating that Fitzsimmons had been convicted in 2019 of a misdemeanor offense described in the document as intoxicated and disruptive. She was in college and she was drunk in public. And I ask you, how many of us have been drunk in public in college? In contesting the Commonwealth's motion, Fitzsimmons relied on a letter from a doctor affiliated with the hospital where she had received treatment after the June 30 incident. The letter indicated that while she was initially held pursuant to General Law 123, she no longer met the criteria for involuntary hospitalization and was appropriate for outpatient care. Then footnote 1 says, the record indicates that this statement referred to an involuntary hospitalization for mental health treatment. Authorizing restraint and hospitalization of person for a limited period where, quote, failure to hospitalize such person would create a likelihood of serious harm by reason of mental illness, end quote. Additionally, Fitzsimmons relied on the report of an expert psychologist who concluded that Fitzsimmons posed no credible risk of harm to herself or others, and that the risk of harm from reuniting her with her child was all but non-existent. After a hearing on August 28th, the hearing judge determined Fitzsimmons to be dangerous, concluding that her release on personal recognizance would not reasonably assure her appearance at future court dates or would endanger the safety of another person or the community. Such bullshit. Nevertheless, pursuant to General Law 276, the hearing judge found that Fitzsimmons could be released subject to conditions reasonably assuring community safety, including, as relevant here, the following. 1. Fitzsimmons was to remain in the custody of her mother and stepfather residing at their home. 2. Fitzsimmons was to remain on 24/7 house arrest except for medical, court, or attorney visits, providing 48 hours notice to the Department of Probation in advance of any such visit. 3. Fitzsimmons' location was to be monitored by a global positioning system, GPS device, and she was not to be released until GPS monitoring was in place. 4. Fitzsimmons was to abstain from alcohol and be subject to breath testing by Secure Continuous Remote Alcohol Monitor, SCRAM. And 5. Fitzsimmons was to follow a treatment plan as provided by 2 specifically named doctors. The hearing judge concluded that these were the least restrictive conditions necessary to assure Fitzsimmons' appearance and protect others. No cash bail was imposed. For reasons not relevant here, the order was stayed until September 8th, when Fitzsimmons was released subject to the above conditions. And mind you, she was supposed to have a surgery the day after she got her GPS bracelet on. And they asked the judge if they could wait and have it applied after her surgery. She would come straight there after the surgery. And the judge said no. She doesn't know of any reason why she wouldn't be able to have the bracelet on during surgery. And we all know that you can't even have nail polish on during surgery. So she had to postpone her surgery. She still hasn't had it. Okay. At a hearing held that day, Fitzsimmons filed a document styled as a quote-unquote medical notice containing representations from counsel about Fitzsimmons' health issues, including that she had trouble breathing as a result of her injuries. At the conclusion of the hearing, Fitzsimmons requested permission to remove the required GPS device for his surgery the following day, but failed to submit any evidence establishing that she could not wear the device during surgery. The request was denied. That's what, yeah, like I just said. On September 10th, Fitzsimmons filed a motion entitled, quote, Defendant's Emergency Motion for Immediate Relief from Scram Order, end quote, in which she represented that due to her injuries, it was, quote unquote, physically impossible to comply with the Scram requirement, as performing the Scram test caused her severe pain and dizziness. The motion attached affidavits to this effect from Fitzsimmons and her mother. It also attached an email message from a probation officer noting that when taking the practice Scram test, Fitzsimmons appeared to be in pain and struggled to complete them. That was Jeff January, and he wasn't just a probation officer, he was I think the head guy. A hearing was held the next day in front of the same judge to address Fitzsimmons' motion. Second part. Okay, and that's footnote 2. Second part provides in relevant part. The hearing under this subsection may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or the person detained if the judge finds that A, information exists that was not known at the time of the hearing, or that there has been a change in circumstances, and Roman numeral 2, that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any other person or the community. While Fitzsimmons' counsel described the request as, quote-unquote, a simple adjustment of terms, the hearing judge disagreed, observing that, quote, one of the reasons to ensure the safety of the community was for her to be alcohol-free, end quote. And she wasn't saying she wasn't going to be alcohol-free. She was just saying it was difficult for her to do the tests. She didn't even say she couldn't do them. She just said, is there another way we can do this? The hearing judge expressed reservations at being asked to amend her orders with, quote-unquote, no medical evidence to support the request. Moreover, the hearing judge said that the probation officer's email message was, quote-unquote, not evidence because it was hearsay. and in any event that she gave it zero weight, quote unquote. Nevertheless, the court took testimony from the probation officer who authored the message, and without objection from the Commonwealth, he testified to the substance of the message, stating that when Fitzsimmons performed practice scram tests, he observed her to be in pain. Fitzsimmons' counsel offered the message a second time, at which point the Commonwealth objected on the ground that the probation officer had already testified to its substance, and the hearing judge excluded it. Fitzsimmons' counsel also purported to rely on the previously submitted quote-unquote medical notice to establish that Fitzsimmons had difficulty breathing as a result of her injuries. Fitzsimmons' counsel argued that it would amount to torture and cruel and unusual punishment in violation of the Eighth Amendment to the United States Constitution to insist that Fitzsimmons remain subject to scram testing. He contended that alternatives for alcohol testing existed, and he suggested the appropriateness of urine testing, but he also acknowledged that it, quote-unquote, might step on the court's other order for house arrest, because Fitzsimmons, quote, would have to go to the facility, end quote, for that testing. Although he asked the court to consider, quote, any other alternatives, end quote, Fitzsimmons' counsel did not identify any others apart from the urine testing. After a recess, the hearing judge concluded that the scram testing condition, quote, was necessary to ensure the safety of the community, end quote. And based on a review of the materials relied on by Fitzsimmons, including the testimony of the probation officer and counsel presentations, the hearing judge concluded that Fitzsimmons could no longer comply with that requirement. Consequently, the hearing judge vacated her prior order releasing Fitzsimmons pursuant to General Law 276 and ordered Fitzsimmons held without bail on dangerousness grounds pursuant to General Law 276. The hearing judge issued a written decision that same day in which she noted that Fitzsimmons' counsel, quote, failed to present any specific viable alternatives, end quote. Fitzsimmons moved for reconsideration, asking the hearing judge to reimpose the prior conditions of release with urine testing in place of scram testing. This time, Fitzsimmons referred to a specific program whereby she purported that she could receive random urine testing at a location 10 minutes from where she was residing. Her motion attached an email message from the same probation officer sent to Fitzsimmons' counsel on September 10th, stating that, quote, the only alternative to scram testing is testing with, end quote, this vendor. The message noted that through this vendor's program, on a day when testing was required, Fitzsimmons would receive same-day notice that she needed to test, and she, quote, would have to travel to one of the vendor's sites to submit to a test, end quote. Days after filing her motion for reconsideration, Fitzsimmons filed a supplemental exhibit, a letter from a doctor at the hospital where she had been admitted for treatment of her gunshot-related injuries. In the letter, the doctor wrote that Fitzsimmons' injuries, which included a gunshot wound to the chest and rib fractures, quote, can cause pain that may persist for several months, end quote, and, quote, can also cause chronic pain that can be exacerbated by movement such as deep breathing, end quote. On September 16th, the hearing judge denied the motion, declining to reopen the hearing pursuant to General Law 276, or otherwise reconsider her ruling. In her written decision, the hearing judge observed that the information submitted in support of the motion was known to Fitzsimmons at the time of the September 11th hearing, pointing to the fact that the attached email message from the probation officer describing the urine testing program at issue was sent to Fitzsimmons' counsel the day before the September 11th hearing. Moreover, the hearing judge observed that, as the message described, the request to employ this particular urine testing program, which was, quote, the only alternative, end quote, would require Fitzsimmons to travel to one of the vendor's sites for all tests, and the same-day notice provided through this program would preclude the 48 hours notice to probation required for the limited exceptions to Fitzsimmons' home confinement. The written order stressed that the requested alternative would undermine, quote, the importance of minimizing the number of times Fitzsimmons was allowed to leave the residence, end quote. Because God forbid this vile human being be let out into the community because she's got such a short fuse, she's on the verge of snapping at any moment. Are you fucking kidding me? They make it sound like she's Hannibal Lecter, for Christ's sake. It's unreal, and I can't get over it. It just blows my mind. On October 2nd, 2025, Fitzsimmons petitioned a single justice of this court for extraordinary relief pursuant to General Law 211. In her petition, as she had done below, Fitzsimmons contested the Commonwealth's version of events but admitted that she took out a firearm during the June 30 encounter with police and that she, quote, raised it to the side of her head in a half-hearted attempt to inflict self-harm, end quote. The petition criticized as intemperate the behavior of the hearing judge at the September 11 hearing, and it asked for relief from the order detaining Fitzsimmons. Specifically, it asked that the order be vacated and that the single justice address bail de novo and release Fitzsimmons on personal recognizance with only the condition of a stay-away order issued not on dangerousness grounds pursuant to S58A, but instead pursuant to General Law 276. The petition also requested that the hearing judge be recused from further proceedings in the Superior Court. I agree. In support of the requested relief, Fitzsimmons argued to the single justice that the bearing judge erred in and, quote, available common alternative method of alcohol testing, end quote, which was a less restrictive alternative to incarceration. The single justice denied the petition without a hearing, concluding that the hearing judge did not err or abuse her discretion. Fitzsimmons now appeals, raising the same arguments that she presented to the single justice and asserting that the single justice was required to conduct a de novo review of the order returning Fitzsimmons to custody. Discussion. Quote, we review a single justice's denial of a petition under General Law 211 for clear error of law or abuse of discretion, end quote. And we must also consider the propriety of the Superior Court judge's underlying bail order, including an order holding a defendant without bail pursuant to General Law 276. Campbell v. Commonwealth, 494 Massachusetts 750. We begin by noting that the charge against Fitzsimmons, assault by means of a dangerous weapon in violation of General Law 265, is a predicate offense for detention pursuant to General Law 276. See Cruz v. Commonwealth. Where the Commonwealth has properly moved pursuant to 58A for pretrial detention on dangerousness grounds, a hearing judge may order pretrial detention only where he or she, quote, finds by clear and convincing evidence that no conditions of release will reasonably assure the safety of any other person or the community. I don't know what the hell's going on with my highlighter. On the other hand, where a hearing judge determines that conditions of release, quote, will reasonably assure the appearance of the person as required and the safety of any other person in the community, end quote, he or she shall order pretrial release subject to the least restrictive further condition or combination of conditions that will do so. Fitzsimmons contends that the hearing judge found pursuant to S58A that the community's safety reasonably could be assured through the imposition of certain conditions of release, and that when presented with Fitzsimmons' request for urine testing in place of scram testing, the hearing judge was required to make that substitution because it was a less restrictive alternative to incarceration that nevertheless reasonably would assure the safety of the community. We conclude that the hearing judge did not abuse her discretion in denying the request. and detaining Fitzsimmons. After the August 28th dangerousness hearing, the hearing judge appropriately imposed the conditions restricting Fitzsimmons' release, including the scram requirement. The evidence presented at the hearing described Supra justified those conditions. Although Fitzsimmons argues that alcohol did not play a role in the June 30 incident, which we all said, the material submitted by the Commonwealth at the August 28th hearing indicated that she, quote, struggled with aggression and alcohol abuse. That is such bullshit. That she had been convicted of an offense apparently arising from intoxicated and disruptive behavior. She was 18 when that happened, and she was away at college drinking. And it was a misdemeanor. And they gave her a law license. I mean, she's able to become a cop, so it couldn't have been that big of a deal. And they're going to hold it against her here. And that she was recently alleged to have become violent when drinking alcohol. The hearing judge properly considered these materials when imposing conditions necessary to protect the safety of the community, conditions that included abstinence from alcohol monitored by scram testing. She's breastfeeding, so I find it hard to believe that she drank. Nobody ever saw her drinking either. Moreover, the hearing judge appropriately concluded that Fitzsimmons could no longer impose condition of scram testing. Fitzsimmons does not contest this finding and indeed has relied on her representations that compliance with scram testing was effectively impossible for her due to her injuries. In sum, the hearing judge did not err or abuse her discretion in concluding that where Fitzsimmons could not comply with the least restrictive conditions necessary to ensure the safety of the community, Fitzsimmons should be detained pretrial for dangerousness. We further conclude that the hearing judge did not abuse her discretion in denying Fitzsimmons' motion for reconsideration on the ground that the alternative to which Fitzsimmons pointed, that is, urine testing, would not reasonably have assured the safety of the community because it would have interfered with the condition of home confinement. Let's read footnote 3 and 4. Excuse me. Fitzsimmons also asserted error in the conduct of the September 11 hearing. She contested the exclusion from evidence of the email message in which the probation officer described observing Fitzsimmons in pain during practice scram tests, but the probation officer testified on this point without objection from the Commonwealth, and the hearing judge ultimately credited that testimony. The message was therefore cumulative of the testimony, and the hearing judge did not err in excluding it. The best source of information is testimony of persons who have personal knowledge. In addition, Fitzsimmons contested the hearing judge's finding in her September 11th order that Fitzsimmons did not submit medical evidence. Fitzsimmons asserts that the medical notice described Supra was medical evidence, but this document contained only representations from Fitzsimmons' attorneys, and in any event, the hearing judge concluded, consistent with these representations, that Fitzsimmons was unable to comply with scram testing. In sum, Fitzsimmons represented that she could not comply with the requirement, and the hearing judge so found. Footnote 4. Before the single justice, Fitzsimmons represented that there were, quote, numerous alternative alcohol monitoring options available, end quote, but specified only 2 others apart from urine. Urine testing. God, their footnotes are longer than their actual body of the paper. Transdermal scram bracelets, which Fitzsimmons acknowledged are not currently available in Massachusetts, and in-person probation check-ins. Period. Fitzsimmons did not propose these alternatives during the September 11th hearing, and her motion for reconsideration was based specifically on a request for urine testing through the program described Supra. Moreover, Fitzsimmons did not provide the single justice with further detail regarding the latter of these two purported alternatives. In any event, Fitzsimmons' representations in this respect run counter to the email message she submitted to the hearing judge and the single justice describing urine testing through the particular vendor at issue as the only available alternative. The single justice, therefore, did not abuse her discretion in denying relief on the basis of these purported alternatives because the record did not establish that they reasonably could assure the safety of the community. She just keeps putting that in there. Safety of the community, safety of the community, safety of the community. I mean, Jesus Christ. We get it. I mean, Jesus, it blows me away. They act like she's some mass murderer. It's so irritating. Indeed, Fitzsimmons' counsel had acknowledged at the September 11th hearing that urine testing might step on the court's other order for house arrest. God damn it. Oh, for fuck's sakes. And Fitzsimmons' motion for reconsideration specified that the urine testing program she requested would require her to travel 10 minutes from her house for any test. 10 whole minutes. You know how much damage she could do in 10 minutes? Give me a fucking break. In denying Fitzsimmons' motion for reconsideration, the hearing judge properly concluded that community safety required, quote, minimizing the number of times Fitzsimmons is excused from house arrest, end quote. Unbelievable. Fitzsimmons also argued that the hearing judge violated Title II of the Americans with Disabilities Act, Title II, in denying her request for alternative testing, which she classifies as a request for a reasonable accommodation, but already requires the imposition of Fitzsimmons' requested relief, i.e., conditional release wherever it can, quote-unquote, reasonably assure the defendant's appearance and the safety of the public. Fitzsimmons provides no citation for the proposition that whereas here, the hearing judge acted within her discretion in concluding that the requested alternative would not reasonably protect the public safety. Title II would nevertheless require its imposition. Americans with Disabilities Act does not require the judiciary to take any action that would fundamentally alter the nature of its activities, end quote. In addition, Fitzsimmons asserted that her return to custody pursuant to the September 11th order was governed by General Law 276 rather than General Law 276-58A. The single justice correctly rejected this argument, observing that the hearing judge was authorized by 58A-4 to reconsider her order imposing the conditions of the release, which is what Fitzsimmons' motion had asked her to do. And indeed, the hearing judge's order holding Fitzsimmons without bail expressly stated that it was issued pursuant to General Law 276-58A. Footnote 5. As noted, supra, Fitzsimmons has also requested that the hearing judge be removed from her case, but Fitzsimmons did not move for the judge's recusal in the Superior Court, and she did not sufficiently develop a recusal argument with citations to legal authority before the single justice or before this court. Wow. Where is it? Conclusion. For all the foregoing reasons, we conclude that the single justice did not err or abuse her discretion in denying the requested relief pursuant to General Law 211. Neither did the single justice err or abuse her discretion in declining to review the detention order de novo. Judgment affirmed. The case was submitted on briefs. Timothy J. Bradle and Martha Coakley for the petitioner. Marina Moriarty, Assistant District Attorney for the Commonwealth. We note, as the single justice also noted, that nothing prevents Fitzsimmons from requesting in the Superior Court that the matter of her pretrial detention for dangerousness be reopened if and when she can show that, quote, information exists that was not known at the time of the hearing on that there has been, or that there has been a change in circumstances, end quote, and that, quote, such information or change in circumstances has a material bearing on the issue of whether safety of any other person or the community. So, that breaks my heart. That absolutely breaks my heart. I heard that tomorrow she has an emergency hearing to reinstate the original restrictions for her release and so that she can go home immediately. So we have this last ditch effort to get her out before Christmas, and God willing, it's going to work. Something's got to work. Poor Timothy Bradle is working his ass off between Aiden Carney's case and Kelsey's case. He's busting ass to keep them both out of jail, and he's kind of having some luck with Aiden, but as far as Kelsey, not so much. Okay, now I wanted to go over the Kelsey's I can never remember his last name. Justin's last name. Let me see. Kelsey. God damn it. Kelsey. Oh my fucking God. Justin Alian. Okay. Let me write that. Aylian. I can never remember that. Justin Aylian. For This is going to piss me off. I just had it on here, too. And my computer kept making me restart it before I came on, so now it's not in my header. Now I'm going to have to go through all this bullshit to sign on to X, and I hate X, or Twitter. It's Twitter. For fuck's sakes. You know what? I will be right back. So, just 1 second, okay? I'm going to try and find this. Okay, sorry about that. Didn't even realize I'd saved it, so. Sorry. So I didn't even have to go through all that. I'm so stupid. I panic. I panic. So, without further ado, let's go over Justin's flippin' thing. Okay, sorry, that didn't work. I swear I have it. Okay. So, shall we? Commonwealth of Massachusetts, the Trial Court, Probate and Family Court Department. Respondent Justin C. Ileon's verified motion to dismiss petitioner's petition for grandparent visitation pursuant to MGLC 119. Now comes one of the above captioned respondents, Justin C. Ileon, hereinafter the father, who respectfully moves this honorable court pursuant to Mass R. Dom. Rel. P. 12 to dismiss with prejudice, so that means never to be taken up again, right? Isn't that what that means? To dismiss with prejudice the petitioners, Lauren Pages, hereinafter Mrs. Page, and William Page, after Page, parent visitation pursuant to, that's a terrible highlight, to, and it gives the statute. As reasons, therefore, the father states as follows. 1. Brief background and procedural history. Or Roman numeral 1, sorry. 1. The father and the second named respondent, Kelsey F. E. Fitzsimmons, hereinafter the mother, were never married and have one child together, namely Caden D. Ileon, date of birth February 6, 2025, age 10 months. 2. The father and the mother resided together with the minor child at 125 Phillips Brooks Road, North Andover, Essex County, Massachusetts. The father presently resides with the minor child at his parents' home located at 28 Maple Street, Stowe, Middlesex County, Massachusetts. 4. Mother is currently being held without bail at the Western Massachusetts Regional Women's Correctional Facility, located in Chicopee, Hampden County, Massachusetts, pending a criminal trial on a charge for assault with a dangerous weapon upon a police officer in the Essex Superior Court. 5. Mr. and Mrs. Page presently reside at 24 Knoll Street Road, Methuen, Essex County, Massachusetts. 6. On or about June 30th, 2025, the father sought and obtained an emergency abuse prevention order pursuant to, and it gives the law, from the Essex County Probate and Family Court. Pursuant to the 209A order, father was granted sole custody of the minor child and mother was ordered not to contact the father or the minor child. The 209A order remains active and a two-party evidentiary hearing is currently scheduled for April 4th, 2026. I don't know why that's being so weird. Okay. On or about July 1, 2025, father filed a complaint for custody support, parenting time pursuant to, and it gives the law, as amended on August 8, 2025 in the Essex County Probate and Family Court. The mother was served with the summons and father's amended complaint on or about September 5th. On or about July 3rd, mother was criminally charged with 1. Armed assault. armed assault to murder, assault with a dangerous weapon, and assault with a dangerous weapon. Okay, he has that on there twice. I don't know why. Mother was arraigned on or about August 7, 25. Okay, but they only handed down one indictment. They didn't hand down the murder indictment. On or about August 25th, 2025, Mother was indicted on one charge for assault with a dangerous weapon in violation, it gives the law. On or about August 28, 2025, Mother was released on bail to be set at personal recognizance. The conditions of Mother's release were as follows: GPS in place, 24/7 house arrest except for medical, court, attorney visits with 48 hours notice, reside with mother and stepfather with no weapons in the home, and Corey checks on all people in the home, stay away from contact with the victim or with the child, and no alcohol with Scram. Sign any and all releases and follow treatment plan issued by Massachusetts General Hospital. Number 11, on or about September 11, 2025, the Essex County Superior Court issued an order which in part vacated the court's prior order of release and ordered that Mother be held without bail pursuant to, and it gives the law. 12, Mother's criminal jury trial is currently scheduled for February 9th, 2026, not 2025, in the Essex County Superior Court. On or about October 2, 2025, Mr. and Mrs. Page filed a petition for grandparent visitation pursuant to, and it gives the law, an affidavit of Mr. Page in support of petition for grandparent visitation, an affidavit of Mrs. Page in support of petition for grandparent visitation, and a motion for temporary orders. On or about October 28, 2025, the court entered a temporary order in Father's and Mother's pending 209C matter, which incorporates the stipulation for temporary orders on plaintiff's verified motion for temporary orders dated October 22nd, and states in pertinent part as follows: the father shall have legal and physical custody of the party's minor child. Mother shall have no parenting time. That just fucking kills me right there. Father will share updates about the minor child, such as his diet, general well-being, development, medical, dental appointments, new activities, discoveries, evolving likes and dislikes, milestone, for example, first steps, first words, as well as photographs and or videos of the minor child to the father's counsel of record on the 15th and 30th of every month. Father's counsel shall share the same with mother's counsel within 24 hours of receipt of the same. Kelsey has been without her baby since June. So June, July, August, September, October, November, 6 months. She's missing some of the biggest milestones in that baby's life. He's probably starting to, try and say his first words. I'm sure he's crawling. She's going to miss her first Christmas with him. She already missed his first Thanksgiving. She missed his first 4th of July. And Justin's not showing him pictures of Kelsey and saying, Mama, this is Mama. He's not doing that. And her parents aren't allowed to see him. So they can't do that, because they would have done that. I know they would have. They would have shown pictures of Kelsey to him all the time so that he knew who his mother was. And I believe, correct me if I'm wrong, but I believe Justin is dating somebody already. So this woman is in this baby's life more than Kelsey is. So who's to say he doesn't start calling her mom? I don't know how Kelsey does it, because it's not even my baby. And I feel such possessive traits right now. I feel so possessive over him, and I feel like that lady has no business trying to take my place in that baby's life. And God damn her for doing so, you know? If she had any moral compass at all, she wouldn't be around the baby. She would make it a point to stay out of the baby's life, knowing that Kelsey does not have a chance to be in the baby's life right now. And you don't want to confuse him as to who his mom is. I can't. I can't. If and or when the minor child is baptized, the father shall ensure that the ceremony is video recorded. The father shall send Father's Council the video of the baptism that same day, and the Father's Council shall forward the same to Mother's Council. The parties agree that the mother's sister, Madison, may attend the baptism. Well, thank God, because he wasn't going to let her. And who the fuck does he think he is, leaving her family out of this baby's life? I mean, what the fuck? And, you know, CPS is always going on and on and on and on about how we like to keep the families together. And that's why they give these animals their kids back after they've been proven to be animals. Okay? Well, why aren't you doing that now? Why aren't you trying to keep this family together? Why aren't you trying to keep this baby's grandparents in his life? I told you, no consistency in Massachusetts at all. It's a shit show. It's a fucking circus. On or about November 13th, 2025, Mr. and Mrs. Page filed a request for status on motion for temporary orders. They used to see this baby almost every day before Kelsey was incarcerated. And now they're completely out of his life. They haven't seen him at all. Do you think Justin's showing the baby pictures of his grandparents at least? No. I can guarantee he's not. He's a piece of shit. On or about November 26, 2025, the father was served with the summons on the petition for grandparent visitation. Argument. Roman numeral 2. This is 15 pages, sorry. Pursuant to Mass R. Dom, whatever. The court has the authority to dismiss a complaint when the moving party has failed to state a claim upon which relief may be granted. A complaint must include factual allegations plausibly suggesting, not merely consistent with, an entitlement to relief. A. The petitioners lack standing pursuant to Massachusetts general law. Pursuant to, and that gives the law, grandparents may petition the court for visitation if the minor child's parents are either deceased, unmarried, divorced, or married and living separate and apart. While the law does not explicitly define the term grandparent, the Massachusetts Appeals Court has held that in regards to requests for visitation by a person other than the biological grandparents of a child, the probate court has the authority to exercise its equity jurisdiction and order visitation by a person who does not have standing under general law. As such, the case law is clear that Massachusetts law relates to biological grandparents only. Mr. Page's affidavit, which he signed under the pains and penalties of perjury, alleges that he is the maternal grandfather of the minor child. Furthermore, the motion for temporary orders filed and signed by Mr. and Mrs. Page on or about October 2nd, 2025, alleges that they are both the biological grandparents of the minor child. Mr. Page and Mrs. Page are audaciously attempting to mislead this honorable court. Mr. Page is not, in fact, the minor child's maternal grandfather. Mr. Page is merely married to Mrs. Page. Mrs. Page is not mother's biological father and is therefore not the minor child's biological grandfather. Mr. Page's marriage to Mrs. Page does not grant him the legal right or standing to petition this court for visitation with the minor child and invade the father's constitutional right to make decisions regarding the care and upbringing of this child. Noting that any third party should not be permitted to seek visitation. Furthermore, mother's biological father, and therefore the minor's child's actual maternal grandfather, is very much alive. Mother's biological father is named Mr. Stephen Fitzsimmons. What a piece of shit. Before the father sought and obtained the 209A order against the mother on or about June 30th, 2025, and since the minor child's birth on February 16th, 2025, Mr. Fitzsimmons visited the mother and father on several occasions to perform maintenance on the house. While Mr. Fitzsimmons was present, the mother intentionally avoided Mr. Fitzsimmons and eventually instructed him to refrain from visiting the house. She must have her reasons for that. Mr. Fitzsimmons, the minor child's maternal grandfather, who has held the minor child approximately 4 times, has not petitioned this court for visitation. Given that Mr. Page is not the biological maternal grandfather, he does not have standing to petition the court for visitation pursuant to the general law. As such, the petition must be dismissed for lack of standing. B. The petitioners fail to meet the heightened pleading requirements required by law. 1. The father has a constitutional right to make decisions regarding the care and upbringing of the minor child. This breaks my heart. The U.S. Supreme Court has long recognized that a parent has a due process right to make fundamental decisions concerning the care, custody, and control of their children. The quote, analysis must be guided by the liberty interest at issue, the interest of parents in the care, custody, and control of their children, which is perhaps the oldest of the fundamental liberty interests recognized by this court, end quote. Quote, the burden of litigating a domestic relations proceeding can be so disruptive of the parent-child relationship that the constitutional right of a custodial parent to make certain basic determinations for the child's welfare becomes implicated, end quote. The Massachusetts Supreme Judicial Court has consistently reaffirmed that the decision of a fit parent concerning grandparent visitation is entitled to considerable deference. There's no question here relative to whether... You want to see my dog, since she's being a little brat and she's making all this noise? Let's see who's making all this noise. Come here. Come here. Can you come say hi? Come say hi. Come here. Up here. Gypsy. Gypsy. Come here. Up here. Come here. They can't see you. They can't see you. Do you see her? She's an Australian Shepherd. She thinks she's the cat's meow. And she's all up in everybody's business, and she's just making all kinds of noise over here. So, hey, that's enough. Sorry about that. Anyway, she's big. She's like 69 pounds. I didn't know that they had different size Australian Shepherds. I thought they were all the same size, but they have small, medium, large. She's obviously large. She's a heifer. There's no question here relative to whether... Just a second. Gypsy... I will be right back. I'm sorry. Okay, sorry about that. Fucking son. He locks her in here, and then he has people outside, so of course she's going to bark. I mean, okay, there's no question here relative to whether father is a fit parent pursuant to both 209A order dated June 30th, 2025, and this court's temporary order dated October 23rd, 2025. The father has sole legal and physical custody of the minor child, and mother has no parenting time, period. Further, as part of the mother's criminal matter pending in the Essex Superior Court, mother was ordered to stay away from the minor child. Oh, that just fucking breaks my heart. And I don't know why this won't go straight. Anyway, Notably, after father sought and obtained the active 209A order against the mother on June 30th, 2025, the Department of Children and Families opened an investigation. However, the case was closed shortly thereafter based on the father having sole custody and the mother having no contact with the minor child. Just one second. As such, the father's decision to deny Mr. and Mrs. Page visitation with the minor child at this time must be, quote, given presumptive validity, end quote, and considerable deference, quote unquote. To succeed on their petition, Mr. Page and Mrs. Page must rebut the presumption that the father's decision not to grant them visitation with the minor child at this time is in the best interests of the minor child. This family's getting fucked from all directions. Number 2, the Massachusetts Supreme Judicial Court has established that petitioners in a petition for grandparents' visitation pursuant to the law are subject to a heightened pleading standard. In Blixt versus Blixt, the Massachusetts Supreme Judicial Court, hereinafter SJC, set a standard that petitions for grandparents' visitation filed pursuant to the general law are subject to a heightened pleading standard. Quote, before a parent or parents are called upon to litigate fully a grandparent visitation complaint with all the attended stress and expenses, the grandparent or grandparents should make an initial showing that satisfies a judge that the burden of proof can be met, end quote. Quote, to this end, any complaint filed under this statute should be detailed and verified or be accompanied by a detailed and verified affidavit setting out the factual basis relied on by the plaintiffs to justify relief, end quote. Accordingly, to survive a rule motion, a Blixt affidavit must contain averments of significant harm that are 1, facially sufficient to rebut the presumption of parental fitness, 2, based on information and relief, and 3, made with particularity and indicating the source of the information, end quote. This showing of significant harm may arise either 1, in the context of a significant pre-existing relationship, or 2, in the absence of such a relationship. A grandparent may prevail only by showing that visitation is nevertheless necessary to protect the child from significant harm. So they have to prove that without them being in his life, he's at risk for significant harm in order to get visitation? Even assuming that Mr. and Mrs. Page have proper standing to petition the court for visitation pursuant to general law, for the reasons set forth below, their petition and affidavits fail to meet the heightened pleading standard imposed by the SJC and must be dismissed. The petitioners failed to allege a pre-existing significant relationship. Quote, in imposing the requirements of harm in the context of a significant pre-existing relationship, the court meant the kind of relationships such as de facto parents or other relationships of close bonding where significant harm may be readily inferred from and is inherent in the disruption of that relationship. The petitioner's affidavits, which were signed under the pains and penalties of perjury, are riddled with inaccuracies and false narratives. Notably, the minor child was only 4 months old when the father was granted sole custody on June 30th, 2025, pursuant to 209A order. The minor child is currently 10 months old. Mr. Page's allegation that he provided, quote, financial and emotional support and as has been a source of stability, guidance, and family continuity to an infant during the first 4 months of his life is absurd. Further, it is curious that Mr. Page felt inclined to include in his affidavit, which must include averments of significant harm that are facially sufficient to rebut the presumption of parental fitness and be made with particularity, that he has provided financial support to the minor child. Even if that were true, it is perplexing how providing more financial support could support a finding of a relationship that should be considered similar to a de facto parent. Similarly, Mrs. Page's allegations that she, quote, regularly cared for the minor child, end quote, and that the minor child, quote, was very accustomed to our presence and care, end quote, and that they have a, quote, unquote, strong bond is perplexing given that Mr. and Mrs. Page were only present during the first 4 months of the minor child's life. Because of you piece of shit. Given that the minor has not seen Mr. and Mrs. Page since he was 4 months old, it is highly unlikely that the minor child would even recognize them, let alone be, quote, very accustomed to their presence and care, end quote. Further, Mrs. Page sets forth 0, quote, averments of significant harm that are made with particularity that support her allegation that a disruption between her ability to spend time with the minor child would cause unnecessary emotional stress and developmental harm. Further, given Mrs. Page's alleged concerns, it is perplexing that she and Mr. Page waited approximately 3 months after the father was granted sole custody of the minor child to file the instant petition. And I'll tell you what, they waited that long because they didn't think they were going to have to go through this to do it. They probably figured you were going to let them stay in his life. They didn't know they were going to have to go through all this shit to get to see their grandbaby. According to the motion for temporary orders filed on October 2, 2025, Mr. and Mrs. Page alleged that they, quote, have a long-standing relationship with the child, end quote. From February 16, 2025, the minor child's birth, to June 30, 2025, the date father was granted sole custody of the minor child, the father and mother rarely brought the minor child over to Mr. and Mrs. Page's home. Mr. Page rarely, if ever, went to the mother and father's house to see the minor child. Mrs. Page would occasionally stop by on her way home from work approximately 2 times per week for 1 hour to see the mother and the minor child. How does he know? He's at work. Additionally, during these 4 months, Mr. and Mrs. Page babysat the minor child for a few hours on 2 to 3 occasions, while the father and mother went on a date or spent time with friends. The father and mother rarely, if ever, left the minor child alone with Mr. and Mrs. Page for more than a few hours. Furthermore, the minor child has never stayed overnight at Mr. and Mrs. Page's home, as given Mrs. Page's excessive alcohol use. Oh my God. The mother and father previously agreed not to allow the minor child to stay overnight at their residence alone. Both affidavits allege that Mr. and Mrs. Page saw the child, quote, every Sunday, end quote, from February 16th to June 30th. To be clear, there were in total 19 Sundays between February 16th and June 30th. Upon information and belief, the father and mother brought the minor child to Mr. and Mrs. Page's residence for Sunday dinners for 2 to 4 hours on approximately only 6 of those Sundays, which is less than half of the Sundays covering this period. Mr. and Mrs. Page's affidavits grossly misrepresent the time they actually spent with the minor child. Mrs. Page falsely alleges that she, quote, saw the minor child almost every day, end quote, from the day he was born. Even if that were true, that amounts to less than 50% of the entire duration of the minor child's 10-month life. As such, the minor child has spent the overwhelming majority of his life without Mr. and Mrs. Page's involvement. The misrepresentations and inaccuracies alleged in Mr. and Mrs. Page's affidavits do not stop there, and Mr. and Mrs. Page also allege the father has ignored their requests for updates on the minor child's well-being and for pictures and videos of the minor child. On or about August 27, 2025, 1 month before Mr. and Mrs. Page filed the instant petition, the father, through his mother, sent a picture of the minor child to Mrs. Page along with a general update. Mrs. Page responded, "Thank you so much for the picture and update." Furthermore, on or about October 3, 2025, before the father was served with the instant petition, or was even aware of it for that matter, the father, through his mother, sent another picture of the minor child to Mrs. Page along with a general update. 2 pictures. Mr. and Mrs. Page's flagrant attempt to mislead this court is instructive on their credibility, and their allegations cannot reasonably be said to be facially sufficient. Even if the allegations contained in the affidavits are presumed to be true and the court draws every reasonable inference in favor of the petitioners, the relationship alleged by Mr. and Mrs. Page does not give rise to a significant pre-existing relationship. Massachusetts courts have thoroughly considered grandparent-grandchild relationships. In Fraser, the Massachusetts Appeals Court held that where the petitioners alleged that the paternal grandparents had, quote, over the years enjoyed many activities with the children, including lunches, dinners, and visits, and spent time with them over meals and holidays. Such allegations do not suggest the type of relationship with the children, plausibly suggesting a right to relief. Similarly, in Dearborn, the Massachusetts Appeals Court held that where the petitioner alleged that they saw the children regularly, several times per month on average, and liked to take the children to local fairs and on 2 occasions for camping trips, and his contact with the children was a mix of grandparenting and providing sitting for the children while their mother was involved in other activities and provided emotional support to the children, the relationship was, quote, a not uncommon one between grandparent and children, and while meaningful and nurturing, it is not the kind of relationship from which significant harm may be inferred from disruption alone. Wow. Mrs. Page's affidavit alleges that quote, my daughter and her fiance would come to our home every Sunday for family dinner. My husband and I also regularly cared for our grandson to allow them to spend time together as a couple, including evenings out. Mr. Page's affidavit alleges that he, quote, regularly saw the minor child multiple times a week and every Sunday for dinner, as well as provided financial and emotional support, end quote. These allegations describe and only permit the inference of a relationship wherein Mrs. Page occasionally visited the minor child. The parents of the minor child brought the child over for the occasional Sunday dinner, and the parents intermittently relied on Mr. and Mrs. Page for childcare. Neither petitioner alleges that the minor child ever resided with them or that they substantially contributed to the care and upbringing of the minor child. They simply enjoyed visiting the minor child when his parents brought him over and occasionally babysat him when his parents needed them to. There are no allegations or inferences therefrom which could plausibly suggest that it is, quote, the kind of relationship such as de facto parents or other relationships of close bonding where significant harm may be readily inferred from as and is inherent in the disruption of that relationship. In other words, Mr. and Mrs. Page's relationship with the minor child was, quote, a not uncommon one between grandparent and child, and is not the kind of relationship from which significant harm may be inferred from disruption alone. Wow. For these reasons, Mr. and Mrs. Page have failed to allege significant harm in the context of a significant pre-existing relationship, sufficient to survive. The petitioners failed to sufficiently allege that visitation is necessary to protect the child from significant harm. In the absence of a significant pre-existing relationship, a grandparent may prevail only by showing that visitation is nevertheless necessary to protect the child from significant harm. Absent some extreme circumstance, the proper consideration is whether the petitioners made adequate factual allegations to plausibly suggest beyond more speculation that visitation is necessary to protect the child from significant harm. Okay, I need to take a break. My mind is numb from all of this. Let me show you some pictures of Kelsey Fitzsimmons. I mean, she's so adorable. And so tiny. For them to think that she poses a threat to the community is unbelievable when you see her. And when you see how small she is compared to Justin. And he's afraid of her. Fuck him. If he's afraid of something that little, he's a piece of shit. He's a pussy. Sorry, but he is. Okay, let me see if I can. Here's a picture of her and Justin. Now tell me that. Oh, she's so pretty. My heart's for her. How come it's not showing that picture then? Okay, never mind on that one. If he's truly afraid of her, he's a pussy. Because look at the difference in their size. Okay. Right here. Look at that. Oh, sorry. I have to show it to you. I have to share it with you. Sorry. Let me see, where am I? Um, um, shit. What is going on now? Okay. Um, nope, that's not it. I was getting too cocky, I think. You know? Um, let me see. God, that pisses me off that I was getting cocky like that. You know? I mean, Jesus. Why I gotta be like that? I was getting really cocky. Oh, Lord. That's terrible. Um, so. Let's see. Um, shit. God damn it. I should have just left well enough alone. Um, fuck my life. I don't think I'm gonna be able to find it. Sorry. I don't know what the hell I did. Okay, so why isn't that showing? Where's the screen? Okay. Let's see. Just 1 second, guys. I don't see a screenshot option. So that's no good. Okay, well, apparently I'm not quite that advanced yet, so sorry. We'll go on. Oh my God, how embarrassing. Yeah. Is this? Nope, that's not it. Shit. Oh God, did I fuck this up? Okay. Okay. Turn me on. Okay, well, now I gotta find what page we were on. Oh my God. We were on 13, I think, right? Why is it going up? Need not accept. Okay. Speculating king. Okay. Okay. Are we ready? In the absence of a significant pre-existing relationship, a grandparent may prevail only by showing that visitation is nevertheless necessary to protect the child from significant harm. Absent some extreme circumstance, the proper consideration is whether the petitioners made adequate factual allegations to plausibly suggest beyond mere speculation that visitation is necessary to protect the child from significant harm. Mr. and Mrs. Page's affidavits do not contain averments of significant harm that are facially sufficient to rebut the presumption of parental fitness, or made with particularity and indicating the source of the information. Mr. Page's affidavit alleges that denial of visitation would cause harm to the minor child's emotional well-being and development. Mr. Page's affidavit fails to state with any level of specificity how the minor child's well-being and development would be or has been harmed without the requested visitation. In other words, Mr. Page has failed to make adequate factual allegations to plausibly suggest beyond mere speculation that visitation is necessary to protect the child from significant harm. Similarly, Mrs. Page's affidavit alleges that she believes disruption may cause unnecessary emotional stress and developmental harm, and that the requested visitation is vital to the minor child's emotional well-being. Mrs. Page is merely speculating that a disruption in the minor child's relationship with Mr. and Mrs. Page may have negative consequences to the minor child. Mrs. Page's allegations fail to state, quote, with particularity, how the minor child's development would be harmed by a disruption in their alleged relationship, and fails to include any adequate facial allegations to plausibly suggest beyond mere speculation that visitation is necessary to protect the child from significant harm. Finally, the affidavits fail to address the fact that since father was granted sole custody pursuant to 209A order, which was over 5 months ago, the minor child has been and currently is thriving. The father and the minor child's medical providers have zero concerns relative to the minor child's emotional well-being, development, and safety. The father has enrolled the minor child in early intervention through which he is ensuring that all developmental goals are met. The court need not accept bald assertions, unsupportable conclusions, paraphrastic circumlocutions, and the like. What the fuck wow, he didn't write this, obviously. Neither Mr. or Mrs. Page filed a detailed and verified affidavit setting out the factual basis relied on by the plaintiffs to justify relief. Instead, the petitioners rely on speculation, conjecture, and bald assertions that a denial of visitation would result in significant harm to the minor child, which is easily rebutted by the fact that the minor child is currently and has been healthy and flourishing. For these reasons, Mr. and Mrs. Page have failed to allege the visitation is necessary to protect the child from significant harm, sufficient to survive a Rule 12b-6 motion. Conclusion. For the foregoing reasons, the case law is clear that the relationship alleged by Mr. and Mrs. Page is not, quote, the kind of relationship such as de facto parents or other relationships of close bonding whose significant harm may be readily inferred from and is inherent in the disruption of that relationship. Mr. and Mrs. Page's affidavits in no way indicate that a failure to order visitation would subject the child to any harm, much less significant harm. As such, the petition fails to set forth factual allegations plausibly suggesting a right to relief for any claim under emancipation. Giannacino? I don't know what that is. Let alone meet the heightened pleadings requirements of Blixt. Therefore, the petition must be dismissed. C. Martinez, whatever. Imposes a requirement to allow a parent's motion to dismiss when the petition fails to allege why a visitation is necessary to protect the child from significant harm. Wherefore, the father respectfully moves this honorable court to allow the respondent Justin C. Allian's verified motion to dismiss petitioner's petition for grandparent visitation and grant the relief requested herein along with such further orders as this court deems meet and just. Verification signed under penalties of perjury. What a Oh, they ruled on it. Here's the ruling for it. Oh my God. Proposed order on respondent Justin Allen's verified motion to dismiss petitioner's petition for grandparent visitation pursuant to general law. After hearing and consideration on the respondent Justin C. Allen's verified motion to dismiss petitioner's petition for grandparent visitation pertaining to the above captioned action, this court orders the following. The petition for grandparent visitation filed by the petitioners Lauren Page and William Page on or about October 2, 2025 is dismissed with prejudice. She didn't sign it though. So ordered. Oh my God. What the fuck? I didn't know that it had been ruled on already. Oh my God, that breaks my heart. So they didn't get a chance to even respond to his response. Wow, I am so blown away right now. Oh my God. Jesus Christ. This family is getting screwed always, all the way around. I mean, they can't catch a fucking break. And this piece of shit who calls himself a father doesn't think that the grandparents need to be in this baby's lives. Well, then that tells you what kind of father he is, right? I mean, the more family around this child, the better off, the more nurturing he gets, the more life lessons he gets, the more love he gets. How can he deny? All I can say is karma's a bitch, Justin. You piece of shit. Karma's bitch. And I hope that you get every bit of karma that you deserve, that you are due. I can't stress enough how bad and how much I can't wait for karma to come looking for you. I mean, move out. Try living alone with your baby. Why don't you do that? You're an adult. Why are you living with your parents? You piece of shit. Quit sponging off of them and move into your own place with the baby and see how well you do. See how much you might need those grandparents. See how much you might depend on those grandparents. Living with your parents, of course it's easy. Because every time you want to go out and party or be with your friends, you just leave the baby home with mom and dad. And you know they'll watch him. I'd like to see a private investigator follow him around for a while and see how often he's really at home with that baby. Is he really at home with that baby, or is he out and about having fun with his girlfriend and leaving the baby home with mom and dad? I mean, how much of fatherhood is he really taking part in? That's my question. My heart breaks for Kelsey, and let me find her give, send, go. and I will post it in Kelsey Fitzsimmons. Okay. I'm trying to find. I know Mazda Media. I believe has it in his shit. Okay, so it's HTTP. And then give send go.com /help Kelsey. Okay, so I'm going to add it into the description. And let me put it in here in the chat also. So it is, sorry, www dot give send go.com /help Kelsey. So if you can give anything, I mean, it doesn't have to be a lot, $1 or $2. Now how do I do? Because she needs us now more than ever. I mean, she's going to be without her baby and most likely her family on Christmas, because they live like 2 hours away from the prison or from the jail. And just please keep please keep Kelsey and her family and baby Caden in your prayers. We will get through this, and we will help her get through this. It may be a harder fight than what we were expecting, but the truth will prevail, and she will get her son back. I truly believe. And everybody has to believe, otherwise it won't work. So she's at the Chicopee facility for women. I'm not sure what the address is there on my next... before I publish or upload this video, I will add it into the description of the video for you. And there are a lot of rules for writing prisoners. So make sure that if you are going to write her, that you look at all the rules. Otherwise, they'll just throw your stuff away. I don't even think they send it back to you. I think they just throw it away. So you won't even know if she got it or not. So if you want to guarantee that she gets it, then I would suggest that you go to the website and read the rules as far as the mail goes, to make sure that yours doesn't get thrown out. Okay, so that's it for tonight, and I appreciate you joining me. And like I said, prayers for Kelsey and her family and little baby Caden. And let's get to fighting, because she deserves none of this. And she's being totally beaten down, and she doesn't deserve it. Any of it. And it's time for her to go home. So with that, I leave you guys. So stay happy, stay healthy, stay warm and stay dry, and get your Christmas shopping done if you're not done already, okay? So thanks a lot again. Or like and subscribe, please. I really need some subscribers. I think I'm doing better, and I hope you guys think I'm doing better. I just need to find my niche, you know? I need to find out what works for me best. And I think that this kind of does, but I think I need to have more of a fun channel rather than an educational. Not that this is boring by any means. I don't think this is boring at all, but I think I need to have a little bit more action in my videos because I tend to get mind numb. And when I get mind numb, I lose all sense of my abilities to read or write or anything. So I think I need to find what works for me, and I'm trying to. So if you're just patient with me and you go on this ride with me, I think you'll be pleasantly surprised at the end, hopefully, as well as I will be pleasantly surprised at the end. But I think I have I think I have the ability to make this a really good, fun channel if you guys just give me the chance. So like and subscribe, and I will see you guys next time. Thanks. Bye.